Piscataway versus Serpico. We have a teacher who loses it in the classroom, is upset because students wouldn't settle down. Students are singing, dancing, whatever. Teacher decides to express his anger by reciting some negative rap lyrics that included the use of the N-word. Students are obviously and rightfully upset about this. Charges are filed. And the teacher in this case, Mr. Serpico, was let go because of the use of the N-word. And that seems like it should be fairly standard. I mean, there's no excuse, and the court said there's no excuse for that type of conduct. As angry as he may have been, that type of expression was not appropriate for a certified teacher. Okay, well, I think we can all agree with that. Arbitration of Bassetti. I think you know where I'm going with this. We have a teacher who also is involved in a situation with students who are less than cooperative, but he doesn't express or recite or shout any rap lyrics. He mutters to himself some words. And some of the students overheard him using the N-word as he muttered this language under his breath. And the students reported it to administration. But Mr. Bassetti, when he was confronted with this, said he didn't say anything. Matter goes before arbitration on tenure charges. The arbitrator says, not that he believes the students over Mr. Bassetti, or that he believes Mr. Bassetti over the students. What the arbitrator says is, Mr. Bassetti may have said the N-word under his breath, but he doesn't remember it. And the reason he doesn't remember it is because he was talking to himself. It was just unfortunate that some students may have overheard him talking to himself, but there was no intent there. And because there was no intent, and he was talking to himself and doesn't remember saying that word, then obviously no harm, no foul. He should be restored to the classroom, which is what the arbitrator did, put him back in the classroom. So here again, we have a board who's taking action against a teacher who at least allegedly used some inappropriate language. Maybe he did, maybe he didn't. But the arbitrator in this case seems to make up facts and create a rationale that even Mr. Bassetti didn't argue in court in his hearing. So our issue is not with whether he did or whether he didn't, it's with the arbitrator just making up facts out of whole cloth. So a little depressing for that case. WD versus Jefferson. We have students using the N-word amongst themselves. They were pranking each other. And you would think that this would be a HIB violation, but in this case, it was not. There's no evidence that the students were unavailable for learning because of the use of the N-word between themselves. Now, a little surprising here that the students weren't found to be in violation of HIB, because we have seen other cases from the commissioner where students use pejorative terms between or amongst themselves, and it was found to be a violation. Here, I think the key is because there was no substantial disruption of the educational environment, meaning that the use of the N-word did not affect the students so severely that they had to leave the classroom. Therefore, there was no disruption to the educational environment. And because of that fact, may explain why there was no violation of HIB here. But really it sends out a confusing message to boards because we're taught that through the Anti-Bullying Act, that boards are responsible for creating a nurturing and supportive environment for all students, regardless. And because of prior cases, you think that would be consistent, but a little bit of inconsistency here. I wish I could explain it to you, but I can't. Moving forward, DD versus Kansas City Board of Education. We have a district claiming that employees failed to respond to repeated acts of bullying in the district. And we've seen this type of case before, so it's not surprising that the court allows this matter to go forward. But what is surprising here in this case is the parents alleged that the harassment was so severe that the students suffered from emotional distress. Okay, we've also seen that claim before. But usually in emotional distress cases, there is some objective evidence. There's records of the students' changing behavior, there's records of visits to a psychologist or psychiatrist, or there's something that says there is emotional damage going on. Here, there's nothing but the allegation. Parents had emotional distress, and the court allowed that claim to move forward. So that's something to keep an eye on. Staying with anti-bullying, a statement that cookies can make you fatter than you are is not a Hibb statement, which was surprising to all of us because we've seen head lice be Hibb, we've seen height be Hibb, we've seen freckles be Hibb. Here, being fat is not a Hibb violation, but a statement saying your father never loved you after the student's father recently passed away was found to be a Hibb violation. Again,
Fatter than you are doesn't mean you're going to be fat. It just means that the cookies can make you fatter than you are.
even so, fatter than you are is a reference to a distinguishing characteristic, right? A student's weight. And the Hibb statute says you can't make any reference, you can't bully someone, single someone out because of a distinguishing characteristic, even head lice. So I would think weight would also be a distinguishing characteristic. But no, the commissioner said no, or the board said, and the commissioner agreed, not Hibb, not a Hibb violation. DeFalco versus Hamilton Board of Education. Speaking of Hibb matters, fortunately, you don't have to have a full-blown evidentiary hearing. You don't have to have a 2-hour session with examination and cross-examination and everything that goes with a full-blown trial, because it's just a Hibb hearing, and if the teacher is found to be in violation, they're not going to lose their job, at least for a first offense. Maybe there's a letter in the file. So the court has said, or commissioner has said, you don't have to go through everything with regard to providing the evidentiary standard in a court of law because the penalty isn't that great. That being said, in Young versus Edry, you do have to provide the teacher with some evidence. You can't just say you're in violation of Hibb and not provide any proof or evidence or statements that there is a violation. Because the teacher has the right to defend him or herself and has the right to see what was being said about him or her in those statements. So even though the statute says that parents are entitled to the Hibb evidence and doesn't mention teachers, it's not fair to prosecute a teacher, even if it's only for a Hibb violation, without allowing them to see the evidence against them, which would be the Hibb statements. Kobrick versus Stevens. A little bit complicated, but we have 2 sets of students in 2 different schools. First school, Mr. Kobrick has an inappropriate sexual relationship with one of his students, and then moves on to the second school. At the second school, Mr. Kobrick also has an inappropriate sexual relationship with a young lady there, who then goes on and graduates, goes on to college. Student comes home from college, tells mom about the consensual sexual relationship. Mom files a complaint and finds out that the school district actually had some knowledge of the prior incident at the first school. At the first school, administration did interview the first girl's father and the first victim herself, both of whom said that there was no relationship, that nothing wrong happened. So because the school did their homework and spoke to the actual victims who lied and denied the relationship, the second school was not held liable under the statute, which was right as Pass the Trash was being enacted. So no liability there, which just goes to show you that administrators really have to do their homework and ask all the appropriate questions in order to protect the district. Arcos versus CRU, the criminal history unit. A bus driver's license was suspended, driving license was suspended because she failed to drop a student off at the end of the run. And we've seen a statute that says if a bus driver fails to drop a student off, their license can be suspended. Here, yes, the bus driver missed the stop. The student was supposed to get off at a certain stop, didn't get off at that stop. Bus driver pulls off. Parent says, where's my kid? Calls the school. School calls the bus driver. Bus driver turns around, says, yes, the student was sleeping. Dropped them off at the appropriate stop. No harm, no foul. But because that stop was missed, the school district alleged that the bus driver was in violation of the act. And the commissioner said, yes, the bus run ends where the student is supposed to be dropped off, not when the bus comes back to the garage or back to the school. So because of that, according to the commissioner, that's why there was a violation, and that's why the driver's license was suspended for 6 months. Now, Mount Olive versus Inglewood. The family wasn't homeless where they lived in a local campground, lived in a mobile home, where there was an allegation that the students were not actual residents. There was an investigation. The investigation revealed that the students had their own individual bedrooms. There was heat, there was water, there was plumbing, there was sewage in the mobile home. So even though it was a camper, the parents had decided to live there for the duration. So that qualified as the residence for these students. In Orange City versus MM, you have a situation where parents are leaving the district and ask the district to kind of stay on because it's late in the school year. They have moved out of district, but they don't want to disrupt the student's education, and ask the board to let the student stay on. The board said no. The board is allowed to say no, and in this case, did say no, and tuition was required because the students were no longer residents. So in your district, you may want to check your policy, because sometimes policies say that when students who are graduating high school or graduating 8th grade, if they're coming up toward the end of the year, they can go ahead and stay through the end of the year. But that's not every district. So you want to check your policy to see what it says about residency, especially during the later months of the school year. LD versus West Orange, also an unfortunate situation where a grandparent was adopting the grandchild. Parent was having some difficulty, but the grandparent had some issues with the paperwork. And there was a period where the student was living with the grandparent without the appropriate documentation, without the appropriate paperwork for several months, and couldn't prove residency, and couldn't prove that the parent had actually taken custody of that child. So because the grandparent couldn't prove custody, tuition was assessed. So we have to be able to prove custody, not just intent to obtain custody. And in the next case, CM versus Springfield, where a parent leased a house to a tenant and lived in a different township. Obviously, that's not residency. You have to live in the house, not just lease it to someone. You have to be there and prove that that's your domicile. CF versus Pequannock. Parents moved into the district. Their child was placed in a certain school. Parents alleged that all students of Latinx heritage were being placed in certain schools. Therefore, that was discrimination. The board said, no, not discrimination. We just have a policy that everyone living in a certain area is going to be sent to a certain school. And it just so happened that a lot of Latinos were moving into, or Latinx were moving into that area. They were all being sent to the same school because of their pattern of moving into the district. So wasn't discrimination. It was the board's policy of making sure that the population was equally distributed amongst the schools. Doe versus Board of Education. You may recall this from last year where the Board of Education in Pennsylvania the Board of Education adopted a policy allowing for transgender students to use the bathroom and locker room of their preference, one which aligned with their gender preference as opposed to the gender that they were born with at birth. The policy was challenged. It was upheld, allowing students to use the locker rooms or restrooms of their choice. And there were privacy concerns that were addressed in the policy, meaning there were single stall bathrooms and single stall showers in the locker room. So this matter was appealed before the Supreme Court, and the Supreme Court denied certification certiorari. So the policy, the case stands as it is, and the policy is upheld. So boards of education should look into their, intent or exercise discretion as to whether they want to have a gender-neutral policy in schools, and may want to check with the board attorney about a recent statute on gender-neutral bathrooms in public accommodation places of public accommodation. SG versus Toms River, a special education case where students wanted to be placed in their placement, but students making sufficient progress, actually making more than sufficient progress. And because that progress is being made, there was no denial of FAPE, no denial of special education, and therefore the parent due process petition was dismissed. Colonial versus GK is a matter where a parent and school district were at odds because the student didn't satisfy the goals and objectives that were in the IEP. The district argued successfully that it's not the goals and objectives in the IEP that really count. What really counts is whether that student is receiving a meaningful educational benefit. And here, where the district court relied on just progress toward the goals and objectives, without taking into account whether the student progressed at all or received a benefit, the case was, the ALJ relied too much on the goals and objectives instead of the actual progress the student was making. So something for your district to consider. SS versus Hillsborough, student records case, where a group of advocates is running around our state of New Jersey seeking student records, seeking special education settlement records, arguably because they want to make sure that students are receiving all the benefits that they're entitled to. Actually, we think they just want new clients, new customers. So, to make a long story short, the advocates here were requesting redacted special education settlement records, and the court said no, you're not entitled to those records because there are concerns of student privacy. Even if the records are redacted, even if names and schools are taken out, the parent still has a right to say, no, there's other information out there that might violate my student's confidentiality, combined with the student record, could allow someone to identify my student, therefore those records should not be released. And the appellate division agreed with the school district here. But the matter is on appeal to the Third Circuit. So we will see, hopefully this spring, what the Third Circuit says. So stay tuned for that decision. TT versus West Essex, a student who needs 120 credits has to have 120 credits. 118 credits doesn't do it, and the board is not wrong for denying graduation for a student, even a special education student, who didn't satisfy those graduation requirements. Staying with special education real quick, in CP versus Clifton, the board is allowed to set policies on independent evaluations. If someone is going for a speech eval or a psychological evaluation, the board can set a cap on that. If the standard rate is $700, the board can say standard rate is $700, that's all we're paying toward that evaluation. So long as the board policy allows for the parent to prove why the evaluation should cost more. In this particular case, the evaluation was $4,300, not $700, $4,300, 4 or 5 times the going rate, and the parents couldn't prove why they needed such an expensive evaluation. So that was denied. So take a look at your policy, talk to your special education director. You may want to set standard rates in your district as well. JT versus Butler, unfortunately in this case, the student had some behavioral issues on the bus, was throwing things and broke out a couple of windows. The transportation company said, we're not going to transport the student anymore because of these behavioral issues, and left the district high and dry. But the district has a responsibility to the student and to the parents, and despite the fact that the transportation company said, no, we're not doing it, the school district had to make other arrangements for that transportation, couldn't just deny that student, regardless of the damage being done to that bus. If a student or the parents lie about the conditions for a unilateral placement or about how severe the effects of the student's conditions are, that can be a basis for the dismissal of the parent's claim. And that's what happened in FR versus Verona. The parents made the student's condition seem to be much worse than it was, and the student really didn't need the accommodations in special education that they claimed. Ethics real quick. Stewart College Achieve versus Patterson in the matter of Stewart in the College Achieve from Patterson Charter School. Board member failed to timely file his personal relative disclosure statements and was reprimanded for that failure. So you want to make sure that you get your personal relative disclosure statement filed. Also, you want to make sure that you get your training done, which is why you're all here tonight, because in Woolridge, a board member did not complete their training in a timely fashion and was reprimanded for failing to do so. So you don't want to be embarrassed for not attending training. You want to make sure you get that done. Gonzalez versus Perth Amboy was a situation where 3 board members were involved in a litigation against the superintendent. That litigation was settled, and the 3 board members voted to approve that settlement wherein they were named as defendants in an ethics complaint. You can't do that. If you're named in a petition, you can't be voting to settle that petition. Obviously, you have an interest in that, which is in violation of the statute. Annie versus Wolf, an allegation we see fairly often is that the board president withheld information from the public because they changed the agenda. Now, you should know that the board is allowed to change the agenda so long as they're not trying to withhold information from the public. So as long as you're not playing games and trying to hide things, you can change the agenda, because we all know that agendas change even at the last minute. Even during the meeting, the agenda can change. And the board should be allowed to have that discretion to change things to meet their demands. Swartz versus Gallagher, staying with ethics. If you're asking the assistant superintendent of your shared services district to come take your superintendent's job while the superintendent is still employed in that job, that's a bad thing. You have to wait till the superintendent leaves before you talk to the assistant about taking that person's position. Thank you for participating. Thank you for staying here for the whole session.